to begin, before we start today's program, by thanking again the University of Chicago Law Review for coming up with the idea and for publishing all these wonderful papers on Frank Easterbrook's jurisprudence over the past 25 years. For those who haven't read any of them, I encourage you to do so. They're a fantastic set of papers on an extremely wide range of topics befitting the judicial authorship that we're celebrating here. Today we have a public law panel. We're going to begin with Professor Masur, whose paper is entitled Booker Reconsidered. We'll then proceed with Professor Stone, who is commenting on American Booksellers Association v. Hudnut. And finally, Professor Huq, who will talk about academic freedom reconsidered. After that, Judge Easterbrook will take some time to respond, and hopefully at the end we'll be able to have some questions from all of you. Without further ado, Professor Masur.
Great. Thank you very much, Tom. Thank you all for coming. It's really a pleasure to be here and get to comment on one piece of the really great opus of work that Frank put together over the last 25 years. So I think it's pretty easy to find a very important and influential Easterbrook majority opinion. I decided to opt for a slightly higher degree of difficulty and try to talk about what I think is maybe his most influential and important dissent, and maybe one of the most important opinions that he's written in the last decade or so. So the case is United States versus Booker, the case that invalidated the United States sentencing guidelines, or at least made them no longer mandatory. And before Booker came along, the system of sentencing in the United States sort of involved three steps. The Sentencing Commission, an administrative body, had set forth a whole series of rules governing exactly what sort of conduct warranted what type of sentence in federal court. Prosecutors were then only required to prove to a jury beyond a reasonable doubt that a defendant had committed a sort of very general, sort of easy crime in some sense. So, for instance, possession of, say, more than 50 grams of cocaine with intent to distribute. They never had to prove any specific part of the conduct or any specific amount of drugs beyond this sort of threshold level. Once prosecutors had gotten that far, they opened up a whole panoply of possible sentences. So the sentence for possession of 50 grams of cocaine with intent to distribute is 10 years to life. And then the prosecutor only had to prove to a judge, beyond a preponderance of the evidence, a whole series of other pieces of conduct involved in the transaction. So maybe the defendant was actually selling 700 grams of cocaine, maybe the defendant had a weapon, maybe the defendant was using a minor in the transaction, any number of other things. And then once the judge had established those facts in his or her own mind, beyond a preponderance of the evidence only, the judge would assign a sentence pursuant to the sentencing guidelines that the Sentencing Commission had laid down. So the problem with this system, of course, was the Sixth Amendment right to trial by jury. Because, of course, the defendant was effectively being sentenced based on a lot of conduct that had only ever been determined by a judge under the preponderance of the evidence standard. So the Seventh Circuit, in an opinion by Judge Posner and over a vigorous dissent by Judge Easterbrook, held the guidelines unconstitutional, held that they could no longer be mandatory, which they were prior to Booker. And Judge Easterbrook's really sort of poignant dissent not only did not carry a majority on his panel, it didn't carry a majority on the Supreme Court either, which voted against him with Judge Posner 5-4. So what the court did was...
I was much more successful on the Supreme Court. I got 4 there.
Right. Right. In fact, you got some, sort of 45% of the justices who were not yourself. On your court, where you got 0% of the judges who were not yourself. So what it essentially did was return to a pre-guidelines world of what we call indeterminate sentencing, in which there are no set rules about what sentence a judge has to give between the statutory minimum and maximum. So after Booker, if a defendant is found guilty of distributing at least 50 grams of cocaine, that defendant is given a sentence of 10 years to life. There are no set rules within that range about governing what sentence the judge has to hand down, and the judge's sentence is only evaluated to determine whether it is reasonable, not much of a standard. So in his dissent in the original Seventh Circuit opinion, Frank made, I think, 2 prescient observations. So the first was that this system of mandatory, administratively made guidelines, which the Seventh Circuit was in the process of holding unconstitutional, would have been entirely legitimate and constitutional had they been made by judges through common law rules. So you can imagine the Seventh Circuit innovating a whole set of rules that said, here is the approximate sentence you get if you distributed cocaine using a gun. Here is the sentence you get if you distributed more than 500 grams. Here's what you get less than 500 grams, etc. Could have all been done with common law rules. Judge Easterbrook points out that would have been fine pursuant to anyone's reading of the Sixth Amendment, but somehow this administratively made set of rules was not. The other prescient observation was simply that a return to this indeterminate sentencing without any sort of guidelines after more than 20 years of the Booker regime would lead to bedlam. And that, in fact, the judges were going to demand something else. And so, in fact, that's exactly what happened. Judges were immediately uncomfortable with this notion that they were going to sentence sort of indeterminately without much direction. And so the appellate courts instantly tried to impose a substantial amount of structure. And they did this by just latching the notion of reasonableness back to the guidelines. So immediately after Booker, there were appellate decisions that said that any sentence that would have complied with the original guidelines is presumptively reasonable. Any sentence that would not have complied with the original guidelines was presumptively unreasonable. That seems like, all things considered, a pretty good solution to this conundrum, but the Supreme Court couldn't buy it, and they couldn't buy it because of the logic of their original decision. If it's unconstitutional to have mandatory guidelines, they said it's unconstitutional to have something that's mandatory in everything but name. So they agreed that sentences within the original guidelines would be presumptively reasonable, but they said no way in which an appellate court can say that a district court sentence outside of the original guideline range was presumptively unreasonable. And moreover, district court judges were permitted explicitly by the Supreme Court to sentence outside of the guideline range, not just because they thought a particular offender was different or they thought the circumstances of a particular case were discrete or different, but because they disagreed at large with the policy prescriptions inherent to the guidelines. Maybe they thought the sentence for a particular crime was simply too low. Maybe they thought it was simply too high. Maybe they thought that there should be a very wide disparity between sentences for distributing powder cocaine and crack cocaine. Maybe they thought those two should have been the same. This was now within the purview of district court judges. So you can imagine there are sort of two important questions whenever someone's sentenced, right? Two institutional questions. Which institutional actor is going to make the decision about what sort of conduct requires what sort of sentence, in other words, setting the rules about sentencing, and which sort of institutional actor is going to find the facts that then place the defendant within that schema of rules. Before Booker, we had administratively created rules and judge-found facts. Since the problem with Booker was the judge-found facts, you would have thought that we would have moved to administratively created rules and jury-found facts. But as sort of no one, I think, but perhaps Judge Easterbrook has recognized, it's not at all what happened. Because of the Supreme Court's decisions, we now have a system of judge-made rules, essentially, because now every judge can determine what policy they think is best under the guidelines, and judge-found facts in addition. Because now, of course, the judge is free to sentence anywhere between the statutory minimum, say 10 years for distributing 50 grams of cocaine, and the statutory maximum. So we have all of the problems of the Booker regime that the Supreme Court objected to, namely the fact that judges are really, in fact, if not at law, finding facts that determine the defendant's sentence in all of these cases. But in addition, we have all of the uncertainty that goes with making every district court judge into his or her own policymaker writ large. So the policy on these crimes could now differ not just circuit to circuit, because the appellate courts have been unable, per the Supreme Court, to impose a lot of restrictions on it, but really policy can differ from district court judge to district court judge across the country. So it's not quite bedlam, as Judge Easterbrook predicted, but it's not a particularly sensible system either. The justice you're getting now is even more highly variant from judge to judge than it ever was in the Booker era, perhaps even in the pre-Booker era. And still, the Supreme Court has not found a way of curing what it saw as the original constitutional problem of defendants having only sort of some minimal set of facts proven to a jury and then being sentenced based on a whole panoply of other conduct that no jury has ever had the opportunity to pass on. So Judge Easterbrook may not have carried the day legally in the Booker case, either in the Seventh Circuit or in the Supreme Court, but it seems as though all of the sort of bad effects that he predicted have now come to pass, and it may soon be time for the Supreme Court or for Congress to rethink the Booker decision in light of what Judge Easterbrook described in his dissent in that case.
Thanks very much, Jonathan. That's terrific. Jeff?
I'm delighted to participate in this event because I am the only one in this room who remembers Frank Easterbrook when he was a law student. I was a third-year student here when Frank was a first-year student, and he was already noticeable. I also am the only one here who voted on Frank's faculty appointment to the University of Chicago Law School, as well as on his tenure promotion. And probably the only one in the room, maybe one or two exceptions, who remembers Frank's appointment to the Seventh Circuit. And like all of my colleagues, I've taken great pride in Frank's achievements over these years. Unlike Jonathan, who decided to take a challenge with a high degree of difficulty, I've decided to take one with a very low degree of difficulty. I've decided to talk about and to write about an opinion that Frank wrote with which I fully agree, and with which, for the most part, the legal profession over the course of the years has come to accept with some enthusiasm, even though with some grumbling. What was particularly important about this opinion is not only that it was profoundly influential on First Amendment law, and indeed I would say probably the single most important Court of Appeals opinion in the area of free speech in the past 25 years, but also that it was decided by Frank shortly after he was appointed to the Court of Appeals. And it was on a very controversial issue about which there was considerable contention. And Frank approached the case with a high degree of confidence, no surprise there, with a high degree of courage, no surprise there, although most judges would have found ways to hedge in the case, but took it head on in a way that, as I say, was quite controversial, particularly for a judge in his first several months on the bench, and nailed it. It was summarily affirmed by the Supreme Court of the United States, and it has been regarded as controlling ever since. So the case was American Booksellers Association versus Hudnut. And the background of the case is as follows. In the early 1980s, Catherine McKinnon, then a law professor at the University of Minnesota, and Andrea Dworkin drafted an ordinance designed to prohibit the sale, production, exhibition of sexually explicit material that depicted women enjoying sexual behavior that showed them in submissive, humiliating postures or in positions in which they were shown as enjoying sexual violence. The rationale of this ordinance was that such speech was harmful to women in a variety of different ways, that it was worthless in the realm of free speech, and that it should be prohibited. And the way they structured it was not as a criminal prohibition, but as a statutory authorized civil action, which empowered a woman who could show that she was in some way harmed as a consequence of the sale, production, dissemination, or exhibition of such material to sue for damages. The Minneapolis Town Council voted in favor of the ordinance, but the mayor of Minneapolis refused to sign the legislation. The city of Indianapolis, however, then got interested and adopted the legislation, which was signed by Mayor Hudnut, hence the name Hudnut in the case. The American Booksellers Association and a wide range of other media organizations immediately sued to enjoin the enforcement of the ordinance on the ground that it violated the First Amendment. And the case came up to the Seventh Circuit, and Frank encountered it in his first few months on the bench. And Frank saw the case quite clearly. The first thing he did, which I found very admirable, is that typically when advocates or judges defend free speech, one of the things they try to do is to minimize the extent to which the speech might have harmful consequences. Part of the argument is we're going to protect this because it's really not so dangerous. It's really not going to inflict any harm on society, so why not protect it? Well, Frank, to his credit, eschewed that approach and said point blank that this sort of expression can indeed have harmful effects. It can perpetuate stereotypes about women and therefore lead to various kinds of discrimination against them. It can reinforce attitudes about women's sexuality that can lead to sexual violence against them. And so rather than shirk the reality that this speech can have bad consequences, in the first part of his opinion, Judge Easterbrook acknowledged that if this speech were to be protected, it's not because it's harmless, it's because there are other reasons within the First Amendment to protect this. And this is a fundamental point about the First Amendment, because the truth is a great deal of speech that we protect under the First Amendment can, in fact, cause all sorts of harm in society. And one of the things that the judiciary has learned over the past 70 or so years of trying to give meaning to the First Amendment is that speech has to be protected in general, even if it is harmful, at least unless the speech is likely imminently to cause grave harm. And the mere fact that speech might cause harm in a whole variety of ways over time has been thought generally to be an inadequate justification for prohibiting speech, and Easterbrook stated that point clearly and quite definitively in his opinion in Hudnut. The second major argument in defense of the ordinance was that, well, this is a form of speech that shouldn't be entitled to that degree of protection. And indeed, the Supreme Court has recognized over the years that there are a limited class of expression that do not adequately serve the purposes of the First Amendment and therefore can be restricted without the government demonstrating that the speech is likely imminently to cause grave harm. And examples of that would be threats, fighting words, commercial advertising, obscenity, false statements of fact, express incitement to unlawful conduct. With those particular categories, the court has recognized, partly for historical reasons and partly for policy reasons, that they can be regulated without having to show the kind of immediate and grave harm that ordinarily is required for prohibiting speech because of its content. And so the argument was this should be recognized as another one of those categories that should also be subject to regulation. And Frank here, again, in a very clear-eyed and reasoned way, first of all, rejected the proposition that this type of expression fell within any of the recognized categories, most particularly obscenity, which has a very distinctive and much narrower definition under the First Amendment than the Indianapolis Ordinance, and therefore rejected the claim that the ordinance fell within any of the recognized exceptions, and then also addressed the claim that this should be added as another category. And the essential argument of the proponents of the ordinance was that who needs this speech? This speech doesn't contribute in any useful way to public discourse. All it does is to cause harm, and therefore it should be regarded as not worthy of full protection of the First Amendment. And Easterbrook basically made two responses to this. The first is that this was largely an argument that the proponents of the regulation didn't like the speech and didn't like the fact that the speech would cause people to have attitudes and ideas that they disapproved of. And that's always the argument that's made when the government wants to suppress expression because they believe that the ideas communicated are bad ideas and harmful, and that itself could not be a justification for recognizing speech to be of only low First Amendment value. But then even more important, Easterbrook made the important insight that this ordinance was expressly directed at a particular point of view. That essentially it said that if you take the position that women enjoy or need or thrive on sexual abuse, then the speech will be prohibited. And as Easterbrook noted, none of the other recognized categories of low-value speech basically were defined in terms of a disfavored idea, and indeed said that you cannot constitutionally define a low-value category of speech, an unprotected category of speech, on the ground that some people think it's a bad idea or a wrong-headed idea. And that proposition really had not been ever fully stated before Frank's opinion in Hudnut. As I say, the opinion was summarily affirmed by the Supreme Court of the United States, and although it was a very controversial issue, it divided liberals among themselves, traditional liberals. Some of them took a kind of ACLU, civil libertarian view about free speech, saying this ordinance has to be unconstitutional. Others took a different view, saying that, well, this kind of harm that promotes discrimination should not be one of the values that the First Amendment is thought to promote. So liberals were at odds with each other in this case. Conservatives were at odds with each other in this case. On the one hand, conservatives don't like sexually explicit material, and so they tended to like this kind of an ordinance. On the other hand, they saw it as an implementation of political correctness, and that therefore it was simply an example of radical lefties trying to restrict speech with which they disagreed, and that therefore this ordinance was illegitimate in the same way that speech restricting Nazis or speech restricting the Klan would be illegitimate. And what Frank did was really to sort of bring most of those groups, not entirely, but most of them together in an opinion that really did, in a clear-eyed way, analyze the question. And Catherine McKinnon has said on a number of occasions over the years since then that no jurisdiction in the United States has enacted a law like the one that was invalidated in Hudnut, and there's only one reason for that, and that's Frank Easterbrook. And some people may not like that. Other people may think it terrific. But it stands as one of the really great decisions of the past 25 years in giving meaning to the First Amendment.
Thanks very much, Jeff. Aziz?
Great, so let me start by adding my thanks to the University of Chicago Law Review, to the organisers of the panel, and to Judge Easterbrook for his gracious participation. Let me start with an observation. Judge Easterbrook isn't typically styled as an advocate of expansive readings of constitutional rights. In a 1992 essay in the Law Review, he wrote that judges should limit themselves only to that portion of the text or rule that's sufficiently complete and general to count as law. And we have to be thankful that in some measure he hasn't stuck to this, otherwise neither Professor Stone nor I would have a topic. So my own paper is also about an aspect of Judge Easterbrook's First Amendment jurisprudence, but it's about a set of cases that are not as well known, nor ought they to be as well known as either Booker or Hudnut. It's a sequence of 4 cases concerning employment disputes at tertiary institutions, tertiary academic institutions. Disputes that tangentially touch upon the idea of academic freedom, a value that is purportedly protected by the First Amendment. And in the paper, or in the essay, I make a very, very limited claim. I don't say that these 4 cases, these employment law disputes, embody some large theory of the First Amendment as it applies to academic freedom. All I say is that my very limited claim is that in these cases, we can find a conception of the university that allows us to refashion and reformulate academic freedom as a constitutional value. In these cases, we find a distinctive and important understanding of how the university is supposed to work. And that understanding is a platform for thinking through academic freedom as a constitutional value. And if this is a doctrinal or a jurisprudential project that's worth pursuing, it's because academic freedom, at least as a legal concept, has fallen into disrepute in recent years. So conscripting a judge like Judge Easterbrook into its cause will likely do far more than a dozen liberal law professors' articles singing academic freedom's praises. So let me begin with some comments about the status of academic freedom today in the jurisprudence. There are 2 cases from the 1950s and 1960s from the US Supreme Court that talk in glowing terms about academic freedom, Keeshan and Sweezy. But the Supreme Court has never invalidated a statute because it violates a constitutional right of academic freedom. And indeed, the court in its more recent jurisprudence has undercut some of the premises of academic freedom. So in a 2006 case called Garcetti v. Cebollas, the court held that when a government employee speaks pursuant to his or her official duties, that speech is not protected by the First Amendment at all, unlike government speech more generally. And as Justice Souter cautioned in his Garcetti dissent, that rule, the Garcetti rule, might be applied to state-employed academics to limit the protection that they had in the performance of their academic functions. And indeed, although the Garcetti court doesn't speak to the question of academic freedom, it concerns a line prosecutor, Lower courts have taken the Garcetti majority's hint. So, for example, the Fourth Circuit has rejected any constitutional interest in academic freedom and says that it is has said that it is merely a professional norm. One of the judges of that court has stated that the public has a right to direct the content and the ends of academic research, state institutions at least, as it sees fit. So on this logic, the proposal several years ago by North Carolina state legislators that state universities in that state would only teach that the faith tradition of Islam was inconsistent with democracy and tolerance would be a legitimate exercise of state authority. Subsequently, the Fourth Circuit's views have been picked up by at least one judge, Judge Silverman on the DC Circuit, in a very powerfully argued concurrence. Nor have academic freedom's defenders rushed to fill the breach. Stanley Fish, for example, has recently published a book chastising academics for their hubris and argued that any effort to transform the professional concerns of scholars into a First Amendment interest is, quote, doomed. Matthew Fishkin and Robert Post, two of the most important academic defenders of academic freedom, have recently published another book essentially giving up on the project of constitutional academic freedom and arguing that it has to be thought of as a purely professional right. So before I turn to Judge Easterbrook's cases, it's worth noting that this there's no such thing as academic freedom approach is not terribly satisfying. Because the status of academic freedom as a constitutional value has to be, it's a comparative question. The question is never, should academics alone of all others benefit from constitutional protection? Clearly, under current doctrine, citizens generally, and also citizens acting as employees of state institutions, benefit to greater or lesser extents from First Amendment protection. The question is, when those citizens, again, either in private or public capacities, are acting as academics, how is the constitutional protection that they obtain under the First Amendment different? Should it be ratcheted up? Should it be ratcheted down? What is it about the academic environment that makes the First Amendment inflected differently? How should we think about the interaction between the distinctive qualities of academia and the First Amendment? And so this is where Judge Easterbrook's opinions are enlightening. And at first blush, they seem unlikely tributaries to any reinvigoration of academic freedom. In three of the four cases, Judge Easterbrook, writing for the Seventh Circuit, turns away individual rights claims brought under the employment discrimination statutes. And in the fourth case, concerning student speech rights, again, there's a rejection of students' interests. In each case, it's the educational institution that benefits from the court's gloss on academic freedom. But it's the characterization of the university in each of those cases that I think is most interesting and powerful. Because in each case, Judge Easterbrook characterizes the university as a peculiar, perhaps unique combination of conditions. On the one hand, he explains, academics not only speak and write for a living and are eager to protect both the public and private interests in freedom to state controversial positions, but on the other hand, they also evaluate speech for a living. They grade papers, they edit journals, they reject poor quality scholarly papers. And while most forms of government, explains Judge Easterbrook, could not penalize any citizen for misunderstanding the views of a Karl Marx or misrepresenting the political philosophy of James Madison, a Department of Political Science can and should show that person the door. Viewpoint discrimination, the principle that Hudnut identifies and articulates, is in fact both endemic and unavoidable in a university setting. But what we might take from Judge Easterbrook's opinions and his description of the university is the following. That in an academic institution, it is a collegial body of professionals that generate and evaluate new knowledge in the form of speech under conditions of shared professional rules and norms. And it's this institutional environment that sustains the continued production of new knowledge, presumably the welfare gain that comes from the presence of the academy. And on this account, academic production thrives only when its norms are determined by scholars, not by meddling federal judges and juries, as would have been the case in the employment discrimination cases that Judge Easterbrook cited, nor by meddling legislators. And so the constitutional adjudication of individual rights arising from academic institutions has to be sensitive to the effects of both legislative and judicial actions on the academic ecosystem. It must protect the ongoing collective application of professional norms within the institutional setting of the university, regardless of whether that institution is public or private. And this is one reason why this is an intriguing treaty, or an intriguing view of academic freedom, is that it invites an approach to the constitutional status of academic freedom that is neither that in some cases will lead to protection of individual interests, and in some cases it will lead to a shaving away of individual rights for the sake of protecting a continuing institutional environment. And I think in that regard, Judge Easterbrook's opinions on academic freedom give us a perspective on the academy that is a useful counter to the arguments offered by the Fourth Circuit and by recent commentators like Fish, not so much Fishkin and Post, that academics are no special favorite of the First Amendment.
Thank you very much, Aziz. Frank, the floor is yours to respond to these three papers.
Oh, thank you very much. I started my legal career in this room when Richard Posner walked to the front and uttered the now famous phrase, "Torts is not my field." He had been recruited at the very last minute to take over from Harry Calvin, who had suffered an illness, and Dick Posner started to kind of make up torts law on the fly. We know what happened after that. So I'm happy to be back here among my friends of the chattering classes, talking again about such things as how academics talk. Let me take these papers in reverse order. The paper about academic freedom, I agree with all these papers because they agree with me. So obviously they're prescient and thoughtful and careful and all of those. And we'll just let that go. The presentation about academic freedom says that my decisions have ruled against claims of freedom. One has to be very careful with this. There is a tendency to assume that claims of civil rights are those things that are being asserted by the plaintiffs in litigation. The academic freedom cases are among many where the defendants have just as much a claim as the plaintiffs. In two of the three cases, the defendants included the provost of the university. I assume that would get Geoff Stone engaged. And in the third, the defendant included the dean of the academic department. I assume that would get Saul Levmore engaged. These were fights among academics about how universities are governed. And the real question is, does it make sense to use the First Amendment to rearrange internal authority within a university in favor of individual professors to the detriment of their departments, where their departments, in one case the math department, in one case the criminology department, and in one case the journalism people, were trying to figure out how best to fulfill their academic mission. Well, put to one side the fact that this is, after all, the University of Chicago, and we should tend to favor competition rather than regulation in doing those kinds of things. But the alternative, if you think that professors make bad or self-interested judgments about tenure or about what kinds of things should be in the student newspapers, just imagine what kind of decisions jurors would make about who gets tenure or what should be in the student newspapers. There's very little reason to suppose those decisions would be better, and almost no reason to suppose that that kind of intra-academic dispute is within the term the freedom of speech. I've said in print that I view Hugo Black as one of my judicial heroes because, among other things, he took the Bill of Rights and the First Amendment seriously. He didn't want to retreat 1 inch from what was there, nor did he want judges to add to what was there. Right? One was going to enforce the actual Constitution on the books. But I do disagree with Justice Black in his understanding of what the freedom of speech is as everything that comes out of somebody's mouth or out of their pen. One always had to understand the freedom of speech as having historical roots. That's what makes me kind of concerned about intra-academic controversies of the kind that have just been described. There's no historical basis for thinking that government would regulate how universities run their own internal affairs, and great historical skepticism for thinking that governments would do well at regulating university affairs. That suggests a cast of mind reflected in the decisions mentioned in this paper, in which the right is a collective right. It's a right held by the university. So don't come to the Seventh Circuit if you think your professor gave you too low a grade on your torts exam. The professor is going to win that case every time. And by the way, this goes for a whole lot of other cases. There were other similar cases, not cast in terms of academic freedom, where one could think about the role of the courts in trying to assess the validity of ideas. One of those sets of cases, I've had a couple along these lines, a scholar has filed a libel action saying my ideas are right, somebody else's ideas are wrong. One professor of psychology filed a libel action saying, I was libeled by a TV show which made fun of my ideas about recovered memory in child sex abuse cases. These TV producers suggested that I was some kind of quack. Well, it may be that my view is the minority view, but we all know that the minority view often prevails in science, and therefore I'm entitled to go to a jury and have the jury say whether I'm right about recovered memories in sex abuse cases. And the opinion of the court asks, do we think there are two ways to resolve these kinds of fights. One is through the standard scientific method in which claims of recovered memory will be subject to more testing and more papers will be written, and the truth may or may not out. The other is in which you submit this to a jury, and the jury will decide what the truth is and whether it's libelous. And the Seventh Circuit came down unambiguously in favor of the market method, or the scientific method, rather than the jury method. That carries over, by the way, to other areas. You see a lot of academic fights move to the court when, say, the plaintiff will show up in an antitrust case and say, look, a really clever game theorist at University X has just written a paper showing how industrial practice Y could be damaging to consumers over the long run, even though it looks like this market is fully competitive. So I've got this great story, or as George Stigler once said, there is no story in industrial organization so bizarre that you cannot find one reputable economist to support it. All right, so the claim is I've got one reputable economist who will support this story, therefore a jury should resolve it. My opinions, at least, have always said, no. Very unlikely that juries will beat the scientific method in figuring out whether these things are true. Come back to court after there's widespread consensus in the profession that X is true, and then we'll formulate a per se rule. But trying to move the academic debate into the judiciary, well, to put it differently, judges are just the regulators with the most general portfolios, and therefore the ones who know the least about what they're talking about. And you probably can't beat the academy that way. Let me turn now to Jeff Stone's paper about Hudnut. And I need to begin by thanking Jeff for many of the ideas that showed up in the Hudnut opinion. He was too modest to mention it, but he and I discussed many of these issues before I went on the bench. I ended up citing a couple of his pieces in which Jeff was developing the viewpoint discrimination approach, which the Supreme Court has now adopted. So one can think of Hodnot as very much the outcome not of me, but of this law school and the ongoing discussion here. But I'm most happy about Hodnot for a completely different reason, which is that it enabled me to win a bet. When Dick Posner was named to the Seventh Circuit, George Stigler thought to take advantage of him by betting. George Stigler bet that Dick's first decision would be reversed. Thinking that Dick couldn't turn the bet down, and thinking that he had a sure thing going, because if you look at the Supreme Court's data, something like 70 to 75% of all the cases they take are reversed. So sure enough, Dick wanted to uphold his reputation, so he took the bet and lost, and the bet was for a dinner at a restaurant to be named by the winner. George named the most expensive restaurant in Chicago, and off they went and had a good dinner. So when I was named, George came to me with the same bet. And like Dick, I could not turn the bet down. I wanted to bet in my favor rather than against myself, but it turned out the first of my decisions that the Supreme Court reviewed was Hodnot. George at first was reluctant to call the summary affirmance the adequate affirmance, but he was soon assured by everybody else that it counted just the same as one in which they had granted review and affirmed it. So I got a very good dinner out of Hodnot. Unfortunately, by the time Diane Wood was appointed, George Stigler was no longer making that bet, maybe having learned his lesson. The other comment I wanted to make about this was that I was happy that Jeff noticed one of what I thought was the most important moves in Hodnot, which was that I accepted the McKinnon view that pornography is in fact harmful. I didn't say it was true. I didn't know then, don't know now whether it was true. There are in fact competing studies in the psychology literature about whether it's true. But it seemed to me very important to accept it as true, and that willingness to accept it as true proved to be the only thing about Hodnot that was controversial within the Seventh Circuit. Some of my colleagues were unhappy with the opinion precisely because it was willing to accept Professor McKinnon's view that pornography is harmful. What they wanted the Seventh Circuit to produce was an opinion saying, this is a stupid law, the supposed ills are phantoms, and it's unconstitutional because it's stupid. And for me, that's not consistent with my theory of judicial review. It's not consistent, I think, with a good theory of judicial review, because that approach to constitutional adjudication sets up the judges as if they were a third chamber of the legislature or somebody holding a veto power. As the president might say to Congress, I'm vetoing your law because it's a stupid law, it achieves the wrong things, right, or it's too costly for the benefits. The judicial branch is supposed to occupy a very different role rather than re-examining the wisdom. Litigation is not supposed to be a repechage round for the losers in the legislature to complain that they should have won in the legislature. So I thought it was terribly important to accept the proposition that there was real harm here and then see whether the Constitution had anything to say on that understanding. So I thought that was the most important thing there, and the one that, if there was controversy about it, the controversy should have been about that. Mm-hmm. Finally, let me turn to Booker. How many of you are puzzled to find me classed as an anti-formalist, aligned with Justice Breyer and against Justice Scalia? Because that, of course, is what happened in the Booker case. Nino Scalia, who also taught in this classroom, was in the majority, and Steve Breyer was the principal author of the dissent. What's going on, however, is not that I have decided that wisdom, truth, and light lies with the pragmatists over the formalists on the Supreme Court. It again has, a case like Booker is again emblematic of the part of my jurisprudence that tries to treat judges as having no different role. I think of the Supreme Court's Booker opinion and its Apprendi opinion as being representatives of the judicial supremacist point of view. And that's summed up in part in my dissent in Booker, which says, how is it that after Blakely and Apprendi, and now after Booker, judges get to do exactly what they say the legislature and the executive branch can't do? The holding of Booker is that the legislature, through the Sentencing Commission, can't adopt rules that say that such and such facts have such and such consequences unless juries determine what the facts are. But judges can do that, right? That was the basis of my dissent in Booker. And what the majority opinion in Booker in the Supreme Court said about that was, that's it, right? Total silence from the majority. There was no effort to defend this difference between judges and other people. I was actually a little surprised that Justices Scalia and Thomas joined the majority in Booker. I understood why they were with the majority in Apprendi. But in Booker, the majority opinion in Booker, well, I have to take that back. There were two majority opinions in Booker. It's actually very complicated. But the Stevens majority opinion in Booker on the merits makes a living Constitution argument. It says, look, what's really happening here is that at the time of the Constitution, there used to be all this judicial discretion over sentencing. And then legislatures got involved and they started moving more and more things from judicial discretion into rule-like things. And that began to reach its apex with sentencing guidelines. But it didn't really reach its apex until Congress passed a law that made some of these provisions mandatory, and then, to make matters even worse, denigrating the discretion of district judges, moved that discretion from the district court to the Court of Appeals on the ground that provided, in other words, that certain sentencing decisions would be subject to de novo appellate consideration. On the rationale, essentially the Condorcet jury theorem, that you're going to get less variance if the decision is made by 3 people than if it's made by 1 person. Stevens was explicit in his Booker opinion that the judges have to modify their constitutional theory in order to fight back. And I found that not only a very odd approach, it's like saying, gee, at the time of the Constitution there were no antitrust laws. We've got to reformulate our constitutional theory to fight back against the antitrust law. I know at least one professor here who thinks that anything that's inconsistent with the common law must be unconstitutional. But only one, right? And it's not something that's normally associated with Justices Stevens or Scalia, for that matter. But it also turns out to be a failure of history. I mean, it's very strange to see a colossal failure of historical understanding at the Supreme Court. At the time of the Constitution, there wasn't total judicial discretion in sentencing that legislatures slowly impinged on. At the time of the Constitution, the norm in sentencing was that for every crime there was a determinate penalty, right? If you committed crime X, like murder, the penalty was death. Maybe you got benefit of clergy, but the penalty was death. If you robbed a post office, the penalty was 25 years in jail. Not the judge could sentence you between 10 years and 30 years. The penalty was 25 years in jail exactly. And if you look at Blackstone says it's really terribly important to have these determinate sentences because otherwise the king's men, i.e. the judges, are going to start impinging on your liberty. If you really want to be free of these overbearing people with the king's remit, what you need to do is have a combination of 2 things. You need to have juries who can acquit in the teeth of the evidence, and you need to have determinate sentences so that once this thing gets in the hands of the judge, you know exactly what's going to happen. You won't have any of this nasty discretion. But after Booker, we end up with the rule that what is actually going on, according to the Constitution, is that anything that looks like rules in sentencing is out, and judicial discretion is in. Now, people like me are inclined to say, isn't that really kind of a Constitution inverted? And I found it very peculiar, therefore, that Clarence Thomas, who is the only genuine originalist on the Supreme Court, signed up. But there we are, so I am happy even today to defend my dissent in Booker and see it still defended. And that's about all I have to say. It's a good thing I didn't place a bet with anybody about Booker, however.
Well, thank you very much, Frank, and thanks to our three commentators, our three authors for today. I suppose the floor is open if there are questions or comments, and this would also include the panel as well if you want to respond.
Come on, we'll call on you.
What was in those sandwiches? A sedative?
There's a
Yeah, sure.
Well, given the combination, in the Booker case, given the combination of what do seem to be some sort of Sixth Amendment problems have to do with sentences determined without complete proof to juries, and given the competing problem of this over-discretion, or overpowering judicial discretion, what to you would seem a good solution, some proper regime that could unite these disparate views and make sentencing look like some sort of reasonable, rational exercise of judicial power?
There are many potential ways of addressing that question, but I will choose two. One, I don't think there's any Sixth Amendment problem. Sixth Amendment entitles the defendant to a jury on the question, did he commit the crime? It is never, as a historical matter, entitled the defendant to a jury on what the sentence shall be for the crime. So we've had everything from the original Blackstonian determinate sentence to the classic indeterminate sentence. There was a period roughly 100 years ago when everybody thought that the right penal philosophy was that the sentence for every felony would look something like 0 to life with relief in the discretion of parole authorities. And much federal, the worst of those kinds was California, which actually had that as the only sentence in any criminal case. The only thing that could happen after you were convicted of a crime was the judge could impose the standard indeterminate sentence, and the adult authority, which was California's equivalent of a parole board, would decide when you got out. We've had everything from the complete determinate to the complete indeterminate. None of those things seems to me to be a problem under the Sixth Amendment. So I don't like the Sixth Amendment premise. But as for what a good thing is, when I was a full-time professor, I published back in 1983 an article called Criminal Procedure as a Market System, which said, to boil it down to very little, which said, look, you can think of the criminal process as the thing that sets the price for crime. And what's really setting the price for crime is not judges, but bargaining in the shadow of the law. Most of the bargaining is done through plea bargaining. That's where the real price of crime is set. And what sets the price of crime, much more than anything that judges do, is how many judges and prosecutors has the legislature paid for. Because the big trade-off in a prosecutor's office is deciding which cases to prosecute at all. They get an intake that is larger than they can possibly handle. So many cases, most cases, prosecution is declined. Prosecution is then taken. How much is the real sentence in a criminal case? The real sentence in a criminal case depends on how much time the defendant can save the prosecutor by pleading guilty and effectively releasing the prosecutor's time to go and prosecute other cases in that amount of time. That's the real market part of the criminal justice system. That's where most sentences are set. They aren't set from in the few people who end up pleading not guilty and going to trial. In that article, I questioned it. That's published in 1983. The statute that led to the Sentencing Commission was enacted in 1984, and it was being much discussed in Congress at the time The two co-sponsors of the legislation that became the Sentencing Reform Act of 1984 were Ted Kennedy and Strom Thurmond. Now just ask yourself what you think of any law that has the enthusiastic support of both Ted Kennedy and Strom Thurmond. Something is very odd here. In any event, my 83 article was very skeptical about that project on the ground that if you really tried to take over and regulate in detail the way district judges were imposing sentence, you wouldn't do anything much about where sentences were really set, which is in the balance reflected by the number of prosecutors. But you could consume big gobs of judicial time. So I was, even back before it got enacted, a skeptic about the guidelines project. And I found myself in Booker in the curious position of saying, well, not saying completely, but, you know, as a scholar, I'm dubious about this. I'm still dubious about it. But, gee, as Holmes would say, if the legislature wants to go to hell, my job is to help them get there quickly and efficiently.
Can I offer a slight dissenting view, or do we have time? Yeah, I mean, I don't have a very strong view on whether there was a Sixth Amendment violation taking place under the guidelines regime, but I do think that there were a lot of pretty serious prosecutorial abuses that were going on. Prosecutors were convicting people of relatively minor offenses, you know, possession of 50 grams of cocaine, and then sort of using that to bootstrap in all sorts of other conduct and getting people sentenced for 30, 40-year terms when they could never have successfully proven all those other facts to a jury. And so, to my mind, the simple solution was always just to require sort of special jury verdict forms. You know, if the problem is that the jury needs to pass on it, ask the jury, how many grams of cocaine did the defendant have if you find them guilty? Did the defendant use a gun? Was the defendant involved in, you know, whatever, transaction with a minor or something like that? And just actually get the jury's take on it, because, of course, the prosecutor was going to present all the same facts to the judge later on. Why the court didn't choose that route and chose instead this insane mishmash of institutional roles is beyond me.
And I think the answer to that is because the Stevens Project was and is to increase the discretion of sentencing judges, not to constrain it. And Stevens, I think, sees juries and legislatures as equal threats to the discretion of sentencing judges. And I think this, to the extent there's any Sixth Amendment here, it's all smoke and mirrors. Any Sixth Amendment argument, it's not a real one. But in that, I am in the minority.
Professor Masur sort of set it up as two decisions. One is who sets the rules, and the other is who finds the facts and imposes the final sentence. And a lot of the Sixth Amendment discussion and some of these concerns that have just been raised are all about who imposes sentence. But it seems like Booker and then especially Kimbrough right afterwards were more of a reaction to the problem with the actual guidelines. That there was a rejection of the federal guidelines because they were just insanely high for vast categories of crime. And I'm wondering if, it's obviously a judicial supremacist point of view that the judges should stop this project. And I'm wondering sort of what your reaction is to just the problem of bad guidelines and how you resolve that. I mean, the politics didn't solve it. I mean, Congress is always going to make harsher and harsher sentences. So is there an appropriate role for the judiciary to put a stop to something when democracy failed?
Well, if the problem is I'm sorry to preempt the answer, but if the problem is that the guidelines are bad, the guidelines can be challenged under the Administrative Procedure Act as arbitrary and capricious. One can deal with the guidelines, but you have to be careful to the extent you think constitutional adjudication is a way to make the world better. Much of what we learn in the social sciences, the University of Chicago is the great leader in the application of social science to law. Much of what we learn in social science is more and more details on the law of unintended consequences. If the Supreme Court says that guidelines are bad and that judges have more discretion, and you're a member of Congress, what do? You jack up mandatory minimum sentences and remove the discretion from the system. I think the one thing on which both opponents of the guidelines and supporters of the guidelines are agreed is that whatever you may not like about the sentencing guidelines, mandatory minimum sentences are unambiguously worse. And we have seen a big increase in them. I would be happy to get rid of them. I don't think they're unconstitutional, but I think they're terrible social policy. and decisions like Booker, I don't want to say put a better floor under mandatory minimum sentences. You would have expected, just as a matter of the outcome of the election last year, 2008, you might have expected the current Congress to repeal some of the statutes creating mandatory minimums under crack cocaine sentences. But they haven't done it. And one reason why they haven't done it is because it's the only floor that after Booker and Kimbrough is there.
Yeah, I mean, very quickly, the only way in which a move to discretionary indeterminate sentencing is a solution to that problem is if you believe, first of all, that the guidelines are too harsh, and secondly, that judges will be more lenient than the guidelines were themselves. I think at least the second of those propositions is very much up for debate. And secondly, the minute you get rid of the guidelines, you rope back in all of the problems with indeterminate sentencing that made people like Ted Kennedy support their promulgation in the first place, namely the fact that you can get massive racial disparities in sentencing, massive geographic disparities, and so on and so forth. So, I mean, you'd have to really believe that the guidelines have gone much too far to think that this is a good solution if the view is that we're treating criminals too harshly.
Anyway, if you're thinking about racial disparate impact in sentencing, at least at the federal level, that again isn't the work of the Sentencing Commission. It's the work of Congress, which put the 100-to-1 crack to powder cocaine ratio into the statute.
So in the list of the categories of speech that are set aside as for limited or no protection under the First Amendment, we heard obscenity, fighting words, and so on and so forth, and buried in there's commercial advertising, which seems to me one of these things is not like the others, commercial advertising. Judge Easterbrook and Professor Stone, I'd be interested in your views on whether that category the commercial advertising sits comfortably in that company.
Jeff, you want to start?
Sure. Yes, I do think it fits comfortably in that, although the rationales are somewhat different. But basically, the argument is that it's twofold, I think. First, that the fundamental protections that the First Amendment is designed to deal with is both political expression and a kind of individual self-expression element to it, and that commercial advertising of goods and services is not political, and insofar as it's motivated almost entirely by economic interest rather than personal self-fulfilling, self-expression interests, it lacks that other category, other element. The other reason why I think there's logic to the conclusion that commercial advertising is not as merits this kind of lesser protection is that there's so much of it in our society that if you had to give commercial advertising the same protection you give to all other speech, it would ultimately wind up in a dilution to the protection that we give to non-commercial advertising. And if you believe intuitively that commercial advertising actually is both more resilient and because of the economic motivation that drives essentially all of it, and ultimately less important to the purposes of the First Amendment, then there's a kind of good reason to nudge it over into the less protected category because it avoids the need to treat all speech the same way we treat commercial advertising, which would, I think, likely reduce the protection we give political speech if we had to treat them all the same. And the way the courts essentially readjusted that is to then turn around and give commercial advertising very substantial protection under the First Amendment. So it's not treated like obscenity. Essentially, it can be regulated only if it's false or misleading, if it advertises an unlawful product, or turns out now, under very unusual circumstances, when the state interest is very high and the connection between the speech and the harm is a pretty close one. So what the court's done is basically separated out from the fully protected speech, but then given it very substantial protection.
I'm about to say I disagree with Jeff's description of where the doctrine now is, but I'll come back to that in the terms of securities law. But my sense of this, I just hate to say what I'm going to say. I rarely say this even in private, and now I'm going to say it in public. I think Justice Douglas got this one right. I don't want to be quoted about this. But he, of course, wrote Valentine against Christensen, which said that advertising is just not speech within the meaning of the First Amendment. And I think as a historical matter, he was right. And I'm therefore very skeptical about giving commercial advertising any status as speech. Again, as I said, this is historical grounds. The difficulty with that position is that things that are advertising also may be standard political speech. The case that got Valentine against Christensen overruled, the Virginia Board of Pharmacy case, was an advertisement for abortion services. And that wasn't, pardon?
No, it was for drugs.
For abortion drugs.
No, Bigelow was
contraceptive drugs?
No, regular drugs.
Wait a minute.
Virginia Pharmacy was regular drugs.
Okay.
Bigelow is the case you're thinking of.
Bigelow, I'm sorry. I won't
Frank
worry
doesn't
about
know
which
his law.
cases.
Whatever.
He's a specialist in the First Amendment. I'm a specialist in antitrust.
So you were a generalist, you know?
Yeah, it means
About a little bit about everything.
a little bit about everything, not very much. Think about New York Times against Sullivan. New York Times against Sullivan arose out of an advertisement placed in the New York Times. And if you think about the ads for drugs or abortions or so on, they have or can have political overtones. That's why the categorical Valentine doctrine fell under a lot of criticism. But as a historical matter, if you just want to ask about advertisements for shares of stock, I find it very hard to deny the historical claim that that's just not speech. And now let me come back to the description about where we are. There are a lot of decisions of the Supreme Court that sound the way Jeff described them, very robust protection and so on. But in fact, we have a whole bunch of silence rules, cases where commercial speech is prohibited. Let me give you two examples where the judiciary hasn't expressed yet any doubt about them. One is during the period when, after you have submitted a registration statement for stock to the SEC, and when that registration statement becomes effective, the issuer of the securities must maintain absolute silence, not only about its shares of stock, but by and large about its entire business. If somebody comes up to them and asks a question about what were your profits last month, the only thing you can say is, my lips are sealed, right? Here's another one. You go to the FDA and you say to the FDA, I've got this great drug for controlling cholesterol. And suppose, and the FDA approves it. And suppose in your test you found that it has some other use, that, it reduces the number of heart attacks, or it solves baldness, or whatever. It is a rule of law that you can advertise, you can talk about the drug for the use for which the FDA has approved it. But if you run an ad saying, and oh, by the way, a well-controlled study shows that this thing also reduces your rate of heart attacks, you've committed a federal felony. Now, I know a lot of people who think that's profoundly stupid, but I wonder whether anybody is about to change that anytime soon. So we live with respect to advertisements, in this kind of curious world where if ads are allowed, it's very difficult to control their substance, but there seems to be widespread agreement that absolute silence can be commanded for certain kinds of things.
All right. Well, thank you all very much. Let's join the